Well, folks, last time I went over the official filing of Stephen's lawsuit by Stephen Glenn and Walter Kelly. This is the same document, but we have answers to all of the questions that they brought up. So we got question 1, nature of cause. This action pursuant to 42 USC and the due process equal protection clauses of 14th Amendment of the United States Constitution seeking to redress wrong conviction and imprisonment of Stephen Avery. Now, that's question 1. So we got Kocourek answering to the one. He denies and affirmatively alleges that these defendants did not violate or infringe on the plaintiff's constitutional rights. And we got Vogel's answer. Defendants deny the plaintiff's conviction and imprisonment were wrongful in the sense of the constitutional violations alleged, and specifically deny that the defendants violated plaintiff's constitutional rights. 2. Jurisdiction is premised upon 28 U.S.C. 1331 and 1343. The amount in controversy exceeds $1 million and may total as much as $36 million. Answer to that question. 2. Deny and affirmatively allege the plaintiff's damages, if any, were not a result of conduct of these defendants. And Vogel's answer to that question. Answering paragraph 2, defendants lack information sufficient to form a belief as to the amount of controversy and therefore deny the same, putting the plaintiff to his proof. 3. Stephen Avery is a citizen of Wisconsin, United States, and who resides in blah 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 in Two Rivers. And then Kocourek answering, deny knowledge of information sufficient to form a belief as to the truth of the allegation asserted, therefore, and deny the same. Answering paragraph 3, defendants admit the allegations. So they admit that Stephen lives in Two Rivers. Number 4, Manitowoc County is a body corporated and politically organized under the pursuant laws of Wisconsin and addressed the county clerk, Manitowoc Courthouse. At all times relevant to the allegations of the complaint, Manitowoc County acted under the color of law within the meaning and pursuant to its official policies, customs, and usages, and final authority of the Sheriff's District Attorney. Kocourek's answer to that: admit that Manitowoc County is a municipal entity created and existing pursuant to Wisconsin law and located at the address stated. As further answer, admit that Kocourek officials and employees of Manitowoc County had acted within the course and scope of their employment and authority. As to the balance of the allegations, deny. And Vogel, answering 4, admit that Manitowoc County is a municipal created and existing pursuant to Wisconsin law, alleged address. Admit that Vogel acted within the course and scope of his employment and authority. Deny the remaining allegations of the paragraph. Number 5. Thomas H. Kocourek is a citizen of Wisconsin in the United States who resides at Shuttle Road. At all times relevant to the allegations complaint, Kocourek was acting, albeit unlawfully, under the color of law within the meaning and within the scope of employment within the meaning. Kocourek sued both individually and in his official capacity as sheriff of Manitowoc County, in which county he was the final authoritative decision maker and policy maker with respect to the office of the sheriff in all respects relevant to allegations of complaint until January 2001. Mick Kocourek was sheriff of Manitowoc County, and at all times he acted within the course and scope of employment and authority. Further answering said paragraph, deny. And Vogel's answer, defendants admit that Kocourek was the sheriff of the Manitowoc County, lack of information sufficient to form a belief as the remaining allegations, and therefore deny the same, putting plaintiff to his proof. Number 6, Dennis Vogel is a citizen of Wisconsin, United States, who resides at all times relevant to allegations of this complaint. Vogel was acting unlawfully under the color of law within the meaning of U.S. Statute 42 in 1983, and within the scope of his employment within the meaning of. Vogel is sued both individually and in his official capacity as district attorney in Manitowoc County, in which the county as the final authoritative decision maker and policy maker with respect to the office district attorney in all respects relevant to allegations of the complaint until the unknown date of 1986. In his official capacity, Vogel is sued with respect to the entirety of his functions as a district attorney of Manitowoc County, in all respects relevant to the allegation of his complaint. In his individual capacity, Vogel is sued with respect only to his executive, administrative, and advice and the counsel functions as a district attorney of Manitowoc County, in all respects relevant to allegations of his complaint. Answering paragraph 6, defendants deny that Vogel acted unlawfully. Further answering paragraph 6, defendants affirmatively allege that whether Vogel was the final authoritative decision maker and policymaker with respect to the office of district attorney. He is. He's the one that decides if they should bring charges against him or not. And Kocourек's answer to number 6, he admits that Vogel was acting within the course and scope of his employment and authority. Further answering said paragraph, deny. Number 7. On July 29, 1985, approximately 4 p.m., one Penny Bernstein was sexually assaulted, beaten, and threatened with her life, and forcibly held against her will on a Lake Michigan beach in Manitowoc. And Kocourek admits that Penny Bernstein was assaulted, beaten, threatened, and forcibly held on the beach in Manitowoc County on July 29, 1985. Further answering said paragraph, deny knowledge of information sufficient to form a belief as to the truth of the allegations asserted, and therefore deny the same. Answering paragraph 7, defendants lack information sufficient to form a belief as to whether Gregory Allen was an assailant, and therefore deny the same, putting plaintiff to the proof. I think I might have jumped one. Nope. Number 8. Allen, who at the time along violent recorded included sex offenses, he engaged in sexual lascivious conduct and threatened violence against women on the same beach 2 years previously to the attack on Penny Bernstein. The prosecutor in the case was Vogel. Assert. Deny knowledge of information sufficient to form a belief as to the truth of allegations asserted and therefore deny the same. Now let's read that again. Allen, who at the time along violated record with included sex offenses, engaged in sexual lascivious conduct, threatened violence against women on the same beach 2 years previously. Now, Dennis Vogel prosecuted him in that 2 years previous. And Vogel's answer is, defendants lack information sufficient to form a belief as to the truth of the allegations, therefore deny the same, putting plaintiff to his proof, except to admit that a criminal complaint signed by Vogel was filed on September 12, 1983, against Allen, accusing him of committing the crime. So he denies it, but then he confirms it. That shit show. Number 9. During July 1985, Allen was under active daily surveillance by members of the City of Manitowoc Police Department for suspected sexually assaultive behavior occurring during the first half of 1985, and up to including July 29, 1985, that was characterized in official police records as the City Department becoming increasingly very bold. Search answer, deny knowledge of information sufficient to form belief as to the truth of allegations asserted and therefore deny the same. And Vogel's response, answering paragraph 9, defendants lack information sufficient to form belief as to the truth of allegations and therefore deny the same. Putting plaintiff to his proof, affirmatively allege that the allegations of paragraph 9 are accurate. Vogel was unaware of any time during the prosecution of the plaintiff that Allen was any such surveillance by the City of Manitowoc Police Department. I don't believe that one bit, because we got Officer Berger from the Manitowoc Police Department contacting both of them, informing them they might have the wrong person. But then you got Penny Bernstein calling in saying she's receiving harassing phone calls. Number 10, Manitowoc Police Department report dated July 14, 1985 stated, this department has completed several complaints recently concerning prowling, window peeping, indecent exposure, and sexual assault ranging from January 1985 through 7/14/1985. In each case, Gregory Allen has been listed as a suspect. Past record intelligence concerning Gregory Allen reveals he is a dangerous individual with a potential for violence. Number 10, Kocourek, answering, deny knowledge of information sufficient to form a belief as to the truth of the allegations asserted and therefore deny the same. And Vogel, answering paragraph 10, defendants lack information sufficient to form a belief as to the truth of the allegations and therefore deny the same. Putting plaintiff to his proof, firmly allege that the allegations of paragraph 10 are accurate. Vogel was unaware of any time during the prosecution of the plaintiff of the existence of an alleged report by the City of Manitowoc Police Department. Number 11. On July 29, 1985, the surveillance of Allen by the Manitowoc City Police was discontinued for most of the day because the department's personnel were assigned to other calls. And Kourourek's answer: deny knowledge of information sufficient to form belief is a truth the allegation is asserted, therefore deny the same. And Vogel's: defendants lack information sufficient to form belief is a truth the allegation, therefore. Now both of these reports were filed on the same day. Number 12. Allen fit the description of Penny Bernstein's assailant, and Allen's photograph was readily accessible to the Manitowoc County Sheriff and District Attorney. Kocourek: deny knowledge and information sufficient to form belief as to. It's like they copy and pasted every answer. And Vogel: defendants lack information sufficient to form belief as to whether Allen fit the description of Penny Bernstein's assailant, and as to whether his photo was readily accessible, and therefore deny the same, putting plaintiff to his proof, firmly allege that the plaintiff fit the description given by Penny Bernstein. 13. Based upon the facts set forth above, Allen should have been the defendant's prime suspect of the sexual assault of Penny Bernstein. Deny. And defendants deny allegation. 14. At the same time Penny Bernstein was attacked, Stephen Avery was shopping trip with his wife and children in Green Bay, with which he had a receipt for that confirmed where he said he was, but they still ignore it. To buy paint for work on his family home. He could count for whereabouts throughout the day on July 29, 1985, and there was corroborating evidence from the witnesses and documents to support his account. Now, when they arrested Stephen Avery that night, they didn't deny him a phone call to anybody because they claimed that his wife already knew he was taken into custody, so he had no reason to inform her. They also denied him a phone call because majority of his alibis for that day were his family, but there was also 18 plus people that claimed he was where he said he was, laying concrete. Yeah, it's a shit show. At the same time Penny Bernstein was attacked, Stephen Avery was on a shopping trip with his family in Green Bay. Yeah. So then we go to their answer: deny the plaintiff's description of the events as full and complete account of the evidence, therefore deny the same. And Vogel, answering paragraph 14, defendants admit that Stephen Avery presented such evidence of his whereabouts throughout the day on July 29, 1985, to the jury at trial of the underlying criminal case, and affirmatively alleged that this jury considered but rejected such evidence. Number 15. On July 29, 1985, Stephen Avery was known to both the sheriff and the district attorney of Manitowoc County, generally in regard to certain prior offenses, and specifically in regard to endangerment of safety incident involving the wife of a Manitowoc County sheriff deputy that occurred in January 1985. That woman was a friend of Manitowoc County Sheriff Judy Dvorak. Also, it was Stephen Avery's cousin. And Kourourek's answer to that: admit that there had been prior incidents involving Avery, but denied remaining allegations as to what the alleged known. As further answer, deny knowledge of information sufficient to form a belief as to the truth of the allegations asserted, and therefore deny the same. And Vogel's answering paragraph 15, defendants lack information sufficient to form a belief as to whether the woman was run off the road and forced from her car at gunpoint by a plaintiff in January 1995 was a friend of the Manitowoc County Sheriff's Judy Dvorak, and therefore deny the same, putting plaintiff to his proof. She lived right across the street from Stephen. 16. There was an attitude of hostility within the Manitowoc County Sheriff's Department towards Stephen Avery and the Averys on July 29, 1985, that included both Dvorak, Sheriff Kocourek, and a similar attitude with Sheriff District Attorney Vogel. And Kourourek's answer to that question: deny. And Vogel's: Defendants deny that Vogel had an attitude of hostility toward Plaintiff and the Averys on July 29, 1985, lack information sufficient to form a belief as to the remainder of the allegations of this paragraph, and therefore deny the same, putting Plaintiff to his proof. Number 17. As a result of hostility, neither Dvorak nor Kocourek nor Vogel possessed the objectivity and that is required in the law enforcement investigation of crimes, such as the committed by Penny Bernstein by Allen. Instead, as each was predisposed against Stephen Avery. Deny and Vogel. Defendants deny as to Vogel lack information sufficient to form belief as the remainder of the allegations of this paragraph, and therefore deny the same, putting Plaintiff to his proof. As a result of this title, neither Dvorak nor Kocourek nor Vogel possessed the objectivity required law enforcement investigation in crimes such as those committed against Penny Bernstein by Allen. Instead, each was predisposed against Stephen Avery. And deny. Defendants deny as Vogel lack information sufficient to form belief remaining an allegation in this paragraph, and therefore deny the same, putting Plaintiff to his proof. Penny Bernstein was severely traumatized by Allen's attack and was transported to the Memorial Hospital in Manuscript, where she was questioned and interviewed during a sexual assault treatment protocol by Dvorak and Kocourek. Although Penny Bernstein's description of the attacker substantially resembled Allen, Dvorak and Kocourek identified Stephen Avery as a probable offender, with immediately focused the Manitowoc crime investigation upon Stephen Avery, intending to permitted meaningfully investigation and other suspects, including particularly Allen. Now, this attack on Penny Bernstein happened around 4 p.m., and by midnight, they were already at Stephen's door arresting him. Admit that Penny Bernstein was injured, transported to the hospital for treatment, and interviewed by Kocourek and others. As further answer, denied. And Vogel's answer to that? Defendants deny the allegations except as follows: lack of information sufficient to form a belief as to whether Allen perpetrated the attack on Penny Bernstein and whether Penny Bernstein's description of the assailant subsequently resembled Allen, and therefore deny the same. Putting Plaintiff to his proof, admit that Dvorak and Kocourek questioned Penny Bernstein at the hospital, and thereafter hearing Penny Bernstein's description of the assailant, Avery was identified as a suspect whose photo should be included in the photo array for Penny Bernstein to view. Number 19. Kocourek ordered procedures of victim identification, including a composite sketch and a photo selection process that failed to follow professional standards, presented Stephen Avery as a suspect, and excluded Allen from the selective process. Penny Bernstein was led to believe that the group of photos presented for her viewing included the main suspect from the sheriff's investigation, considered to be her attacker. Stephen Avery's photo was included. Allen's photo was not. Answering, admit that the composite sketch was prepared based on Penny Bernstein's description of her attacker, and that the photo selection was presented, which included a photo of Stephen Avery. As further answer, they deny, or he denies. Answering 19, defendants lack information sufficient to form a belief as the truth of allegations, and therefore deny the same. Putting Plaintiff to his proof, except as the follows: admit that the composite sketch was prepared. Admit that the photo array included Stephen Avery. Admit that the photo array did not include Allen's photo. Deny implication in this paragraph, and that Allen was actively considered and specifically excluded from the process. Affirmatively allege that the Wisconsin Court of Appeals, in affirming Plaintiff's conviction in a written decision dated August 5, 1987, ruled that the photo array constitutes one of the fairest ones the court has seen. Number 20. According to well-known professional victim eyewitness identification principles, once a victim identifies a particular person as a criminal perpetrator, that identification becomes more likely to be repeated on later occasions. Penny Bernstein identified Stephen Avery as her assailant when she examined the photos presented to her by Kocourek. A subsequent live lineup was arranged just 3 days later by Kocourek, who had since consulted Vogel, and again Allen was excluded from the array. Stephen Avery was included, and Benny Bernstein was advised that an arrest had been made by the sheriff's department, and the arrestee would be in the lineup. Stephen Avery was the only person in the living lineup whose picture had been shown to Benny Bernstein in the group of photos provided by the sheriff. And their response? Admit that Benny Bernstein identified Avery as their assailant in both the photo selection and the lineup. As further answer, deny. Answering paragraph 20, defendants lack information sufficient to form a belief as to the truth of the allegations, and therefore deny the same, pointing plaintiff to his proof, except as follows. Admit that Benny Bernstein identified Stephen Avery as her assailant when she examined photos presented to her. Admit that Avery was included in the live lineup, and that there was only one person in the lineup whose photo had also been included in the photo array shown to Benny Bernstein. Admit that Allen was not in the lineup, but deny the implication of the paragraph that Allen was actively considered and specifically excluded from the process. Excuse me. Although Kocourek had discussed the investigation and conferred with Vogel less than 8 hours after the arrest of Stephen Avery, approximately midnight on July 29, 1985. Although Vogel had prosecuted Allen 2 years previously for assault of sex crime on the same beach, neither Kocourek nor Vogel initiated or pursued investigatory efforts to consider Allen as a suspect, and Kocourek and Vogel cooperated in planning the execution of the live lineup. Deny that Kocourek had knowledge of Allen's criminal history, including those alleged. As further answer, deny knowledge of the information sufficient to form a belief as to the truth of the allegations asserted, and therefore deny the same. Where was I? 21. Defendants admit to Vogel and prosecutor Allen 2 years previously denied the prosecution was for an assault of sex crime on the same beach. Further deny that the implication of the paragraph that Vogel actively considered Allen as a suspect, but excluded him from the lineup. Defendants lack information sufficient to form belief as the remainder of the allegations, and therefore deny the same, pointing plaintiff to his proof. 22. Kocourek and Vogel knew in July 1985 about Allen's 1983 conviction for the lewd and lascivious and assaultive behavior on the beach. The report of the incident was contained in the sheriff's file investigation of the attack on Benny Bernstein and was signed by Vogel. Moreover, the sheriff's department knew it was December 15, 1983. Both Allen would be exposed himself, masturbated in front of women, children, and had a history of sexually violent behavior, including the fact that he was the chief suspect in the murder of a 15-year-old girl in North Carolina in June 1975. Answering 22. Deny that Kocourek had knowledge of Allen's criminal history, including those alleged. And as further answer, deny knowledge of the information sufficient to form a belief as to the truth of allegations asserted, and therefore deny the same. Answering paragraph 22. Defendants lack information sufficient to form a belief as to the truth of allegations, and therefore deny the same, putting plaintiff to his proof, except as follows. Defendants admit that on July 1985, Vogel had signed a criminal summons and a criminal complaint, both dated September 12, 1983, against Allen, accusing him of a crime of indecent exposure as a result of the incident occurred on the beach of Lake Michigan at a stretch that was within the City of Two Rivers Police Department jurisdiction. Not that Vogel was aware of any North Carolina incident in 1975 allegedly involving Allen. 23. Shortly after the arrest of Stephen Avery, the City of Manitowoc Police Department Detective Thomas Bergner approached Kocourek and attempted to discuss Allen Allen's history and his department current concerns about Allen as a prime suspect in an attack on Penny Bernstein. It was Bergner's impression that Kocourek knew about Allen and Allen's history. Kocourek told Bergner that Allen had been ruled out as a suspect. The statement is incredibly inconsistent with Kocourk's repeated denials following the event stated in 4-4 hereof that he had knowledge of Allen in August 1985, thereafter until September 10th, 2003. Deny knowledge of information sufficient to form a belief as to Bergner's opinions or impressions, and therefore deny the same. As further answer, deny. Answering paragraph 23 for Vogel. Defendants lack information sufficient to form belief as to the truth of the allegations, and therefore deny the same, putting plaintiff to his proof. Number 24. Pursuant to the official policy, custom, and usage in 1985, Kocourek made no memorandum or writing of Penny Bernstein investigatory file that recorded the contents of the information provided to Bergner. Wow, how convenient. Deny it. Of course he denies it. Answering paragraph 24, defendants lack information sufficient to form a belief as to the truth of the allegations, and therefore deny the same, putting plaintiff to his proof. Number 25. Further, pursuant to this official policy, custom, and usage in 1985, Kocourek made no request indirectly of the City of Manitowoc Police Department, whether before or after his conversation with Bergner, information concerning Allen. And Kocourek's answer to 25. Admit that Kocourek made no request to the City Police Department. As further answer, deny. And Vogel. Defendants lack information sufficient to form belief as to the truth of the allegations, and therefore deny the same, putting plaintiff to his proof. Bergner believed that Allen should have been investigated as a prime suspect, as in the assault of Penny Bernstein, because he was a suspect in other sexual assaults at the same time, including attempted sexual assault on July 14, 1985, in Manitowoc. Troubled by Kocourek's disinterest in pursuing Allen as a suspect, particularly in the view of then current alarm by City Manitowoc officers, Allen was accelerating his sexual assault of Bergner contacted Penny Bernstein. Answering, deny knowledge of information sufficient from a belief as to the truth of the allegations asserted, and therefore. Now, obviously, Stephen Avery's attorneys talked to Bergner before they even brought this suit to them. Entry number 26, defendants lack information sufficient to inform belief as to the truth of allegations, and therefore deny the same, putting plaintiff to his proof. It's like copy and paste for all the answers. Number 27, Penny Bernstein herself was concerned at the time, a concern she was communicated to the sheriff that she was receiving harassing phone calls of sexual nature shortly after she entered her home, causing her to feel that she was being watched. Penny Bernstein contacted Kocourek and told him of Bergner's information. She was alarmed that her assailant might still be at large and stalking her, behavior that was consistent with Allen's history. Answering number 27, admit that Kocourek had discussions with Penny Bernstein, but deny that the plaintiff's description of those calls entirely accurate or complete, and therefore deny same. As further answer, deny. And deny. Kocourek did not tell Penny Bernstein of Allen's existence, history, or surveillance. He did not tell her of Bergner's alarm, of the city department's pointed concerns about Allen. He did not tell her of ruling out Allen as a suspect. Instead, he told her to disregard the matter and that he would take care of it, as the case was with Manitowoc County sheriffs, not the cities. 28. Admit that Kocourek had discussion with Penny Bernstein, but deny that the plaintiff's description in the calls entirely. And then 29, 30, 31, 32, deny. Same thing with all these. 30 captain detectives and other members of the sheriff's department in 1985 expressed their beliefs to the sheriff's investigation focused too quickly and specifically upon State Stephen Avery and the exclusive of other suspects, including a man known for committing sex crimes like one on Penny Bernstein, which matched Penny Bernstein's description, and who was seen in the area where Penny Bernstein's sexual assault took place at the time it occurred. The search would allow the investigatory personnel to no further investigate pursuits of suspects other than Avery in pursuit of Allen. And deny. 32. Upon information and belief, Kocourek told Vogel about Bergen's information concerning Allen's Penny Bernstein's ensuing phone call, further information and information, objections, and investigatory personnel. Again, deny. And just like Vogel, defendants deny allegations, defendants deny allegations, defendants deny allegations. Upon information and belief pursuant to his official policy, custom, and usage in 1985, Vogel made no memorandum or other writing for Penny Bernstein's prosecutorial or investigative file in the district attorney's office concerning the information provided to him by Kocourek about Bergner, Penny Bernstein's concerns, and information and objections of Kocourek's investigative personnel. Denied allegations stated against Kocourek. As further, answer. Denied knowledge of information sufficient to form a belief as to the truth of the allegations stated, and therefore deny the same. And Vogel's response, deny that Vogel had any such official policy, custom, and or usage in 1985. Further deny that any such alleged information or objections provided to him. Number 34. Further pursuant to his official policy, custom, and usage in 1985, Vogel made no request to the City Manitowoc Police Department for information concerning Allen. And Kocourek denied knowledge of information sufficient to form belief as to the truth of the allegations asserted, therefore deny the same. And Vogel, defendants deny that Vogel had any such official policy, custom, and usage in 1985. Defendants lack information sufficient to form a belief at the truth of the remaining allegations, and therefore deny the same, putting plaintiff to his proof. At the time of the investigation and prosecution of the attack on Penny Bernstein, Vogel knew the members of his office staff believed in objective reason and grounds that Stephen A. Avery was not the person who attacked Penny Bernstein, and that Allen was the person who attacked Penny Bernstein. Upon information and belief, Vogel discussed the views of some members of his staff with Kocourek. Deny allegations stated against Kocourek. As further answer, deny knowledge of information sufficient to form a belief as to the truth of the allegations asserted, and therefore deny the same. And Vogel's response, defendants deny allegations. 36. Pursuant to his official policy, custom usage in 1985, Vogel made no memorandum or writing for Penny Bernstein prosecutor investigative file in the district attorney's office, either the views of his staff members set forth. Hereof the discussion of these views with Kocourek. Number 36. Deny the allegations as stated against Kocourek. As further answer, deny knowledge of information sufficient to form a belief as to the truth of the allegations asserted, and therefore deny the same. And 36 for Vogel. Answering paragraph 36, defendants deny that Vogel had any such official policy, custom, and usage in 1985. Further deny that such alleged views were expressed to him or discussed with Kocourek. Number 37. Had Kocourek and Vogel reviewed police reports from the Manitowoc Police Department on or July 29, 1985, the following information would have been specified, adding the likelihood of Allen being a prime suspect in an assault on Penny Bernstein. And its subparts, deny knowledge of information sufficient to form a belief as to the truth of the allegations asserted, and therefore deny the same. And Vogel, defendants lack information sufficient to form a belief as to the truth of the allegations, and therefore deny the same, putting plaintiff to his proof. A. Allen had convicted of aggravated offense as a juvenile. B. According to the police report from Two Rivers, August 2nd, 1983, Allen came up over some dunes on the same beach where Penny Bernstein was attacked and assaulted, only some distance south of that point, and began walking behind a woman, which then he attacked. 3. Following the incident, Allen contacted the victim twice at her home and asked her to drop charges. D. Allen was convicted on February 2nd, 1984 for disorderly conduct in Two Rivers. 1983 or 1984, June 13th, he was a suspect in a prowler. Allen was a suspect on January 24th and February 2nd, involving walking into people's yards and up to their garages, prowling basically. January 26th, Allen was suspect in investigation with a woman told Manitowoc police at 6:30 a.m. she saw a male subject wearing a ski mask between a yard and neighbor's yards, and the suspect had taken a brick, moved it to the other side of the yard. June 26, 1985, 1 month before Penny Bernstein's assault, Allen was a suspect of going into a woman's front door at 2:30 a.m. and exposing himself. On July 14, 1985, 2 weeks prior to Penny Bernstein's assault, Allen was suspected of breaking into a man's home at 3:20 a.m. and attempting to assault his daughter. Number 38. All the information concerning Allen alleged hereof material exploratory evidence that was timely requested of Vogel and Kocourek by attorneys representing Stephen Avery and was not provided to them. This was severely prejudicial, and the information would have prevented the prosecution and the conviction and imprisonment of Stephen Avery between 1985 and 2003. Wow, another incident where the prosecution doesn't give defense information they're supposed to. 38. Deny allegations and state against Kocourek as further to answer, deny knowledge of information sufficient to form belief as to the truth of allegations stated, and therefore deny the same. And Vogel, answering paragraph 38, defendants lack information sufficient to form a belief as to the truth of the allegation, and therefore deny the same, putting plaintiff to his proof, except as it follows. Admit that the plaintiff's attorneys made certain requests for exculpatory evidence, to which Vogel properly responded. Deny implication of this paragraph is that Vogel had all of the information regarding Allen, and alleged the incorporation of the paragraph and close to withheld it from plaintiff's defense counsel, firmly alleged upon information and belief that the files of the plaintiff's defense attorneys underlying criminal case contained a series of police reports in paragraph 8 above, as well as other police reports and the suspect, and one report that does not name a suspect, all of which appear to have been obtained from Vogel as a result of pretrial discovery requests. 39. All acts, omissions set forth, committed by Kocourek and Vogel were intentional and of reckless disregard of the rights of Stephen Avery. And their response to 39, deny. Answering paragraph 39, defendants denied allegations. Number 40. The different treatment of Stephen Avery and Allen as possible suspects in the attack of Penny Bernstein was without rational basis and was premised upon personal hostility towards Stephen Avery. Deny. And defendant denies allegations. Policies, customs, uses, and alleged in 24, 25, 29, 31, 34, 36, and 38 are those of the Manitowoc County acting through the highest ranking authority of law enforcement decision makers, its sheriff, district attorney, and where causes of failures exculpate Stephen Avery as alleged in 38. And their response to that, deny for Kocourek. And Vogel, defendants deny allegations. 42. After the conviction of Stephen Avery, essentially maintained the innocence, he sought by appeal and post-conviction remedies to set aside his convictions. His attorneys continue to pursue exculpatory evidence, notwithstanding their affirmative obligation to provide information concerning Allen's alleged, and all those reports that Manitowoc Police Department had. And of course, deny that Kocourek improperly failed to provide Avery information. Further answering the said paragraph, deny knowledge of information sufficient to form belief as to the truth of matters asserted, and therefore deny the same. And Vogel, defendants lack information sufficient to form belief as to the truth of allegation, and therefore deny the same. Putting plaintiff to his proof, except as follows: admit that the plaintiff sought by appeal and post-conviction remedies to set aside his conviction. Deny that Vogel failed to meet any obligation to provide information. Deny the implication that Vogel was aware of or had information concerning Allen alleged in prior paragraphs in the complaint. Firmly allege that Vogel left the Manitowoc County District Attorney's Office in 1986, had no further authority or responsibility. But he is well aware of Gregory Allen because he prosecuted him 2 years earlier. 43, 1986, March. Vogel prosecuted and convicted, like I'm just talking about, convicted Allen for sex offenses, which was again brought to Vogel's attention as all expository information concerning Allen that should have been provided to Stephen Avery or his attorneys. Kocourek, deny, and Vogel, defendant's lack of information sufficient to form a belief as to the truth of allegations, and therefore deny the same, putting plaintiff to his proof. 44. Due to the efforts of the Wisconsin Innocence Project and conclusion that DNA evidence, Stephen Avery was exonerated and released by a final court judgment in September 2003. The same DNA evidence conclusively implicated Allen, who had committed further violent sex crimes between 1986 and 1995 in the assault, beating, and attempted murder of Penny Bernstein. 44. For Kocourek, admit that Stephen Avery was released. As further answer, deny knowledge of information sufficient to form belief as to the truth of the allegations asserted, and therefore deny the same. Answering paragraph 44 for Vogel, defendants admit that the plaintiff was released by the final court judgment on September 2003, lack information sufficient to form a belief as to the truth of the remaining allegations, and therefore deny the same, putting plaintiff to his proof. 45. The actions and omissions of the defendants, Kocourek and Vogel, in Manitowoc County, targeting Stephen Avery, failing to investigate Allen, as alleged. Stephen Avery deprived Stephen Avery of his due process of law, so comprehensively as to shock the conscience in violation of the Due Process Clause in the 14th Amendment of the United States. And of course, deny and deny. Number 46, second cause of action. These actions, omissions, and defendants Kocourek and Vogel, Manitowoc County, alleged thereof the differential treatment of Stephen Avery and Allen as suspects in Penny Bernstein assault case upon grounds of personal hostility, rationally deprive Stephen Avery of equal protection of the laws that provided the 14th Amendment of the United States. And Kocourek deny, and of course Vogel deny. The actions and omissions of defendants Kocourek and Vogel, Manitowoc County, is alleged. Family record provide defense counsel Stephen Avery material expository evidence concerning Allen that was timely and lawfully requested, severely prejudiced Stephen Avery and denied him due process of the law violation 14th Amendment of the United States. And Kocourek answering deny, and Vogel deny. Post-conviction, continuing failure of defendants Kocourek and or Vogel, Manitowoc County, come forward with material exculpatory evidence known to them concerning Allen throughout the 18 years of Stephen Avery's imprisonment constitutes violation of due process and equal protection clauses of the 14th Amendment. And of course, deny. Damages. As a result of actions and omissions of Kocourek, Vogel, and Manitowoc County, as alleged, Avery has suffered a loss of his liberty and dignity for 18 years, has been treated by society as the worst kind of criminal for 18 years, has suffered destruction of ordinary civilian opportunities to work, earn a living, and economic and social benefits that accompany an earned living for more than 18 years, has become permanently, economically, and socially disabled, has suffered a loss of personal autonomy of his most intimate, personal, and familiar relations, and has been deprived of countless experiences of life that accompany free citizenship. I forgot to include that he wasn't able to see his twin sons grow up because he was arrested 2 days after they were fucking born. And of course, deny. Number 50. The actions and omissions of the defendants Kocourek and Vogel alleged there of an intentional and or reckless disregard of the rights of Stephen Avery are so outrageous that warrant the imposition of punitive damages upon each of the exceeded 1 million and could total up to 18 millions cumulatively. Number 50, deny. And Vogel, deny. I think I missed 49. Sorry. As a result of actions, no, I didn't. Okay. All right. Now, these are Kocourek's affirmative defenses. The defendants of Manitowoc County, Thomas A. Kocourek, to submit the following affirmative defenses plaintiff's complaint. Plaintiff's complaint contains claims which fail to state and claim upon which relief may be granted against the answering defendants. Injuries and damages sustained by the plaintiff, if any, were caused in the whole or in part of the acts and omissions of the plaintiffs or persons other than the answering defendants. Plaintiff's claims are barred possible statute of limitations. So they're trying to say that the statute of limitations have run out for them to even be charged. Plaintiff claims the barred principle of issues preclusion. All of the acts of these answering defendants are protected from the suit by immunities, including qualified immunity. So they tried to use the qualified immunity too, which they need to get rid of. Number 6, plaintiff claims he precluded by the 11th Amendment statute of the United States Constitution. Number 7, plaintiff prevented from a right of recovery against these defendants because an intervening or superseding cause resulted in the damages claimed. Plaintiff has failed to join indispensable parties of the litigation contrary to the Wisconsin statutes. Plaintiff's claim in part may be barred by the virtue of accord the satisfaction for a payment received. Punitive damages are barred by the state law, federal law, and those protections contained within the state and federal constitution. And to the extent that the plaintiff's purposes allege that the state claims under Wisconsin law, they are subject to limits and acquisitions contained within the Wisconsin statute. Further in section especially bars the right to punitive damages. Moreover, the defendants respectfully request a judgment as follows: for dismissal of the plaintiff's complaint upon the merits, for the costs and disbursements of this action, for reasonable actual attorney fees pursuant to 1988, and for such other relief in court deems just and equitable. Dated on this date, October 10th, or December 10th, 2004. So Stephen filed his lawsuit on October 10th, and they got back to him 2 months later. Defendants hereby request a trial by jury. Now we'll go to Vogel's affirmative defenses. As to separate and affirmative defenses, defendants allege that these answering defendants have absolute immunity and are immune from suit and liability of Vogel's actions as prosecutor of underlying criminal action against plaintiff. As a second affirmative defense, defendants allege that these answering defendants have qualified immunity or are immune from the suit or liability for Vogel's actions because those actions were performed and discharged with his official duties, which were discriminatory in nature, performed in good faith and belief that they were necessary to discharge his official duties. As a third affirmative defense, defendants allege that the plaintiff has failed to join indispensable parties. As a fourth affirmative defense, defendants allege that the plaintiff's claims are barred by the doctrine of issue of preclusion. Number 55. As a fifth affirmative defense, defendants allege that the complaint fails to state a claim upon which relief may be granted against these answering defendants. In the sixth affirmative defense, defendants allege that the event all punitive damages are not preempted or barred by constitutional, statutory, or regulatory laws of the United States. In the event the defendants reserve all the defenses against an award which indicates the influence of passion or prejudice, or is otherwise excessive, protected by the Constitution, statutes, and the case law of the states of Wisconsin, as well as defendants against the award, grossly excessive in violation of due process clause and other guarantees afforded by the Constitution and the amendments of the Constitution of the United States of Wisconsin and the state of Wisconsin. Number 57. His seventh affirmative defense, defendants allege that to the extent plaintiffs asserts that claims on the grounds based on the state law, the claims are barred for failure to satisfy requirements. As an eighth affirmative defense, defendants allege that the extent plaintiffs asserts the claims on the grounds based on the state law, the amount of recovery by plaintiff for the damage of injuries may not exceed $50,000, and the punitive damages are recoverable provided by State Statute 893. The ninth affirmative defense, defendants allege that the plaintiff alleged injuries or damages were caused, in whole and part, by the persons answering defendants. As a 10th affirmative defense, defendants allege that the prosecution and the conviction of Stephen Avery were not the product of intentional, irrational, arbitrary, differential treatment, but rather were rationally based on facts developed and considered by defendant Vogel following the attack on Penny Bernstein. In the exercise of prosecutorial discretion, including but not limited to Penny Bernstein's description of her assailant, composite sketch drawn within the hours of the attack, and an evaluation of Stephen Avery, an assailant. Avery's prior criminal record, which included felony conviction for 2 counts of burglary, a conviction of cruelty to animals, and charges depending in July 1985 reckless endangerment arising from an incident that occurred in January 1985 involving a female victim, which Avery was sentenced in separate proceedings to 6 years in prison. Avery's own incriminating statements at the time, shortly after his arrest, and physical evidence corroborated the accusations against Avery. Wherefore, defendants requested the dismissal of plaintiff's complaint on the merits and with costs and fees, and such other relief as the court deems just. Dated this date, December 10, 2004. Defendants request a jury trial. So yeah, they deny. They requested to go to a jury trial. I'm assuming they thought that it'd go to a jury trial and they'd be able to bribe them to find them not guilty. But we never got that far. But so this is the 4th document out of 72. This one cost $3.70. The other ones cost about $2.70. Each page is approximately 10 cents. I know to get the whole case file for the Penny Bernstein, it's going to be $37.80. I'm waiting on that. I'm going to go through everything, start from the beginning. I even dive into his other previous cases. It's a shit show, but see y'all next time.